So, calling docket number 166566, People of the State of Michigan versus Curtis Allen Morris. Council, you may begin your argument. You have 2 minutes of a fire-free zone, which you may waive, and you may reserve some time for rebuttal. If you do, we just ask that you keep track of it yourself. But please begin whenever you're ready.
Your Honor, am I supposed to hit these buttons here, or they go by themselves?
No.
Okay.
Our car will handle the buttons and the lights for you. But if you want to reserve a couple minutes, just let us know and he can help keep track.
Thank you. Good morning, Justices. May it please the Court. I am Charles Cavello. I am attorney for the appellant Christopher Morris, or Curtis Morris. This court has held in applying a statute, the statute is to be given a reasonable and common sense reading, and that penal statutes are to be strictly construed, and any ambiguity is to be resolved in favor of leniency. The Court of Appeals did not follow those principles in their decision. First, to score my client, Mr. Morris, with OV-19, a court must find, quote, by his conduct, unquote, he threatened the security of a penal institution. The dictionary definition of conduct is personal behavior or way of acting. A reasonable and common sense understanding of conduct is that it is some kind of voluntary action. But Mr. Morris's bringing or being found with meth in the jail was not voluntary on his part. He had been arrested, handcuffed, put in the back of a police vehicle, and brought to the jail. If he knew he was going to be arrested that day, he wouldn't have had meth in his pocket, if he did have meth in his pocket. The Court of Appeals wrote, quote, defendant was being placed in jail for a separate offense, unquote. Being placed in jail means that...
That's just the end of your free fire.
Oh, thank you, Your Honor.
Yeah.
Means that being placed in jail means that someone else was putting Mr. Morris in jail. A reasonable, common sense analysis of the situation is that the defendant was arrested and brought to the jail involuntarily without a chance to divest himself of any methamphetamine or any other dangerous item. And therefore,
Counsel,
he did not...
would you agree that there are circumstances where someone is in the booking area and it could be a threat? If they had drugs, are there circumstances where it could be a threat to the penal institution?
Your Honor, it's a little hard to hear you because...
Sorry, it's sort of echoing. Try to back this up. Would you agree that there are circumstances where a defendant could be in a booking area of a jail and that it still could be a threat to a penal institution?
I do, Your Honor.
So what would that look like?
Well, if the person came in with a substance that is dangerous, generally dangerous to everybody, say, I'm trying to think of what it was, anthrax. If a person came in with a bag of anthrax, if anybody touched it, that's a danger to the people working at the jail. So that would be one example of something that I would say is a threat to the jail.
So is for your analysis, for us to agree with you, there's sort of an element of voluntary versus involuntary. Is that the distinction?
On this first argument, yes. Yes.
Okay.
And with the results of that?
I'm saying the statute requires a course of conduct. It requires that. And so the question is that his conduct if he's dragged into the jail?
So would that, under that logic then, would that be carving out a giant exception for every detainee? Anybody, which is probably most people, who are brought into the booking area of a jail are brought in voluntarily. So this would be a huge exception if it has to be voluntarily brought in under that logic. So no
Yes, Your Honor.
detainee could ever meet that standard.
Yes. I do believe that the statute should be read that way.
Okay.
Because again, they put course of conduct in there for a reason, and I think the reason is it has to be deliberate.
So is there a distinction between being brought into the jail booking and being brought in, the voluntary conduct being brought into the booking with drugs? In some aspect, and I understand your client's position that he wasn't aware of it, but that he voluntarily had the drugs on him, even if he wasn't voluntarily going into prison or into jail. So why would we not look at the fact that he voluntarily had drugs on his person as the voluntary conduct?
Well, I understand that, and I've seen that argued in cases on this issue, but again, I'm asking, what I think this court has held in the past is we're going to apply a reasonable and common sense analysis to this situation, and I believe the only reasonable common sense analysis is if you're brought into the jail involuntarily and you happen to have something on you, it doesn't have to be meth, it could be a screwdriver in your pocket. They could say, well, that's dangerous, that's a weapon. You know, we're going to score you for OV-19.
But going to your screwdriver analysis, eventually at some point as they go through the booking process, an inventory is done of what's on their person. And if the screwdriver is found then, you, I think, have a better argument that there is no conduct on the part of the defendant. It was in his pocket, it was removed in the booking process. But couldn't the conduct be, if for example, in your scenario, whether through neglect or intentionally, he decided, I shouldn't have this screwdriver on me, I'm going to drop it in my chair so I don't have it through the booking process. Now I understand you're saying he didn't intentionally drop it, but still at some point it's conduct to either permit it to fall off your person or intentionally do so. Couldn't that be the conduct that's required under OV-19? Because once it's on the floor in the jail, even though it's at the booking area, there are going to be other people who could pick it up, take the drug, who knows what the effect of the drug is on them, and it creates a dangerous situation in this building with this jail and booking area.
Judge Czar, I think all of you, if you're connected, and I have to listen to you from that, it's very hard. I get the gist of what you're saying, but I'm not getting all the details of what you're asking.
So the conduct.
Right.
If he just had it on his person, went through the booking process, and then eventually when you are about to be put into the jail and you are inventoried and everything on your person is removed and you're given different clothes to wear and it's discovered then, I feel more sympathy for there's no conduct. What did he do? But when the drugs fall off the person in the jail, and then we're going to assume the booking area is in the jail. I know you make the argument that it's not. Isn't that sufficient conduct to create circumstances to support OV-19? Because now it's on the floor, for whatever reason, whether it was intentional or by neglect, it's on the floor where other people going through the process might find it, take the drugs. Meth affects people differently. They could, all of a sudden decide to start fighting with the security police officers in the area. So the fact that it's off of his person in the booking area, couldn't that be conduct under OV-19?
Well, Your Honor, I would, I guess I wouldn't agree with, personally, I don't agree with that analysis in light of the way the statute is written.
If it was, I understand there's a question of whether it was by neglect or intentional. If the act was intentional, oh my gosh, I realize I've got meth here, I'm going to drop it on the floor. Would that be enough for OV-19?
I don't believe so, Your Honor. He's put in this situation. He's taken off the street and handcuffed. I think you have to think of this from his point of view. If they, you know, he knows he's going to be, well, if this happened, he never admitted that it was just meth. But any person in that situation is going to try to drop something if they know, if they don't want to get caught with it red-handed on their person. But is that the kind of conduct you want to apply this statute?
So your argument basically is that's the opposite of a threat to the penal institution. You're trying to get rid of it.
Exactly. But again, he's put in this situation that he didn't volunteer for. He didn't plan to show up at the jail with meth. He was dragged off the street, and he was handcuffed in the back of the police cruiser. He's not going to be able to get rid of anything. So I guess his choices would be, well, does he tell him, or does he, like, drop it or something? And I think that's maybe the situation he was in.
Or does nothing.
If he does nothing, they're going to find it on him and charge him with meth possession.
What do we do with the fact that he did disclose other drugs? He did disclose some Suboxone, right? That was in his wallet.
Yeah. Well, again, he wasn't planning to go to the jail, so the way I read the statute, it wouldn't apply. Even if he says he has it, or it falls off him, or they find it on him, all of those circumstances, my focus, and the focus I wish you would accept for the state of Michigan, is that if a person is arrested and brought to the jail, what happens in that booking area, that can't be called their conduct.
So would you agree that somebody's conduct outside of the jail could threaten the security of a penal institution?
You could have people in the parking lot shooting mortars carrying drugs into the jail.
Phone in a bomb threat.
Right. Anything.
So that, is your position that whether it's inside or outside is really not relevant, or does the location of it play into the analysis of whether or not it was a threat, whether or not it was voluntary?
The location is important because the Court of Appeals made an issue of it. I mean, they defined jail for you, as if you didn't know what a jail was. That's the purpose of that area, is to intercept harmful material. And they said, well, it's a threat to the people in that area. Again, I don't think common sense and reason lead you to that conclusion. Those people that's what they're there for. That's what that room is for, to intercept anything dangerous from getting back into the housing area. And that would be my second argument, that processing people into jail is a routine procedure.
But you would agree that there are, I think in response to Justice Welch's question, that there are certain items that could present a danger in the booking area.
Yes, by their very nature, as I said, the anthrax would definitely, that's a threat to everybody. You could have a ticking time bomb on you, I suppose, or, there's things you could have that would threaten people, definitely. But this is a case of, meth is fairly prevalent around here, everywhere, and to me, it's a routine situation, and the rule of law should be with routine, common things that people are picked up with. Say, for example, a person buys some marijuana at a dispensary, and they get arrested on the street and handcuffed and brought in, and they have a big bag of marijuana in their pocket. Are we going to say that's a threat to the jail?
So I just want to make sure I understand. Take the meth out, put a little bit of anthrax in the back pocket, left the house with it in the morning, doesn't expect to get arrested,
Right.
gets arrested,
Yep.
officer does a search, doesn't discover it, brings him into booking. Can you get OV 19 points for that?
Yes.
But you can't for the meth.
Yes, because like a bomb, anthrax is inherently dangerous. It's dangerous to everybody at all times.
What about heroin?
I would not put heroin in a dangerous to everybody at all times. A bag of heroin, a bag of meth, a bag of marijuana, those are, I know you folks do as much criminal work as I do. That's routine for police to find that stuff all the
It's
time.
routine
They're
to
always
find
finding
it,
that.
but don't you think, I mean, whether it be meth, marijuana, heroin, fentanyl, whatever it may be, in a jail has the potential to threaten the security of it. It's not allowed in the jail.
Exactly, sure, I understand
There are
that.
consequences to people possessing it. So why is it, and in Dixon, I think we recognize that there are certain items that can be inherently dangerous and inherently threaten the safety of a penal institution. Why are drugs not that? Or are you drawing the line between type of drug based on how sort of commonly it's possessed?
If he had gotten through intake and into the housing unit with the drugs, OV-19 would apply, in my opinion. But the fact that, I think you have to make a reasonable, common sense analysis of the situation. He's in processing. He hasn't been admitted to the,
So does your case rise or fall on whether processing is considered part of the jail?
that would be my second argument,
It
yes.
doesn't rise or fall on that. You're saying, first of all, there's no dangerous substance. Meth is not dangerous, heroin's not dangerous, anthrax is, fentanyl not so sure, or maybe that's not dangerous. It doesn't rise or fall on whether that this is housing. That's your second argument. Your first argument is this substance just isn't dangerous.
No, my first argument is this, it's not conduct when a person is picked up off the street and brought to the jail.
To me, that's the third argument to me.
Oh, okay, well,
Okay. Your time has expired, thank you.
Better or?
You did not say anything.
All right, thank you.
Thanks.
Good morning, Your Honors. Zachary Stempien on behalf of the state of Michigan. It is an honor to be here. May it please the court. In this case, OV-19 was properly scored in consideration of the purpose of the offense variables and the facts of this case. Not long ago, this court in Dixon reiterated that each OV reflects a particular factor that the legislature believed to be important in determining an appropriate sentence. We all know that the purpose of the guidelines are to eliminate disparity and to create a more uniform approach in determining an appropriate sentence. I offer to the court today that the application of the non-binding sentencing guidelines in this case did exactly that. In this matter, OV-19 was scored based upon post-offense conduct of bringing methamphetamine into the Branch County Jail. This court long ago in People v. Smith indicated that OV-19 almost always contemplates post-offense conduct. And frankly, that makes sense. A court sentencing a defendant wants to sentence a defendant based upon all the circumstances surrounding them, not just the moment in time when the crime was committed. By scoring conduct such as that found in this case within OV-19, it creates a uniform approach to post-offense conduct to a defendant's sentencing, which certainly advances the purposes of the Michigan sentencing guideline. That opposed to much greater discretion, which can be found under MCL 777.34, to exceed the guidelines if the conduct is not otherwise considered within the guidelines. In this case, OV-19 functioned exactly how the legislature intended it to. It assigned a set point value to a defendant's conduct in lieu of less restrained consideration by the trial court outside the parameters of the guideline. Now, I certainly understand that the court is looking to further define what conduct means in regards to OV-19. And the court defined what the test is for OV-19 in People v. Dixon, which was mentioned a couple moments ago. And essentially there's a two-part test, that the defendant engaged in conduct and that conduct threatened the security of the penal institution.
Counsel, I just have a question.
Yes, sir.
Explain to the court, if you could, why is it that these drugs pose a danger? We've heard the distinction between arsenic and things of that nature, which is understandable that could pose a real danger. But what is it about these specific drugs or these specific products that is such a danger to the institution? Yes,
it's my belief that methamphetamine is one of the most dangerous drugs that we have on the streets currently. Methamphetamine mixed with other drugs certainly reduces or causes overdoses. It causes erratic behavior. It causes violent behavior. In fact, methamphetamine is so dangerous that the legislature chose to make it the only drug in the state of Michigan that, based upon the drug alone, is a 10-year felony. Every other drug has a weight component to it. So methamphetamine, regardless of if you have a gram or 10 grams, it's a 10-year felony. In my experience, certainly methamphetamine is a dangerous substance that creates behavior that is unpredictable, dangerous, and violent to everybody else around them.
Counselor, if it was cannabis, would a defendant have been charged with OB-19, or should a defendant have been charged with OB-19? So
I think cannabis is certainly an evolving substance. Obviously, in the state of Michigan, it's a legal substance now. I think cannabis goes more in line to what we would view alcohol as. And there may need to be additional facts in regards to cannabis of whether or not that truly threatened the security of the penal institution. That compared to a substance such as methamphetamine, which has no medicinal purpose, it has no legal purpose. And I direct the court back to some of the language that we talked about in Dixon, where the court pointed out that a cell phone is legal for people to possess outside the penal institution part of it. Cannabis is legal for somebody to possess outside of the jail. Methamphetamine is illegal for anybody to possess. So certainly I think cannabis would be a different analysis, but I think at the end of the day, when we look at the facts of this case, methamphetamine is certainly something that inherently would be dangerous within the confines of a jail.
Are you familiar with the recent Court of Appeals case of People v. Hines?
I am, Your Honor, yes.
What would you have to say about that case?
To be frank with the court, I find it unfortunate, and I kind of cite back to People v. Ward, Justice Young's opinion, that it is my opinion that when we look at defendants' behavior and defendants' conduct, Michigan criminal law should never be in a place where we excuse the conduct because it puts them in an uncomfortable situation. I think it's been alluded to a couple of times today that, the defendant voluntarily at some point in time possessed these controlled substances. They then, yes, they were arrested, they were brought to the jail, presumably involuntarily. I do not dispute that. But the fact that they now have to choose between an undesirable result doesn't mean that the court cannot consider OB-19 in the conduct within the jail. And I think as a bigger picture, I think it's important that we remember that we're talking about conduct and we're talking about the offense variables in this case.
So you would agree that, if defendant had, as part of the booking process, said, oh, I've got, I've got some drugs on me, then no problem, not scored?
I 100% agree to that. And actually, as kind of an offer of the court, I had that same scenario Monday in a sentencing, and OB-19 was not scored on that. And I think that goes back to what we're trying to define conduct as. When we look at conduct, the conduct of either having methamphetamine fall out of your pocket or throwing methamphetamine on the floor, however it got there, that is conduct that threatens the security of the jail. Conduct of saying, hey, I have methamphetamine on me, it's in my pocket, that's conduct that does not threaten the security of the jail because now we're appropriately divesting ourselves of that controlled substance. There's a distinction there.
Scored, but could somebody, even if they disclosed it, be charged with possession?
Potentially, they could be.
So, as noted in Hines, you're saying it's an uncomfortable choice or result, but it's really a choice between disclosing it and risking the offense variable, or choosing. It's not sort of a choice. It's a protected constitutional right against self-incrimination. It puts somebody. This isn't just sort of, well, you could have chosen differently, right? This is a right that our Constitution protects to not self-incriminate.
Absolutely, and I think there's 2 points on that. One, when we're looking at offense variables in and of themselves, we're talking about scoring a non-binding tool that is used to come up with an ideally proportional sentence. We're not talking about necessarily criminal liability within the confines of the offense variables. So a defendant may have to choose, am I going to divest myself of that or potentially have OB-19? However, I would say realistically, and again, applying kind of a common sense approach to this, there are very few defendants in this world that are going to go into that situation going, if I give up these drugs, I'm not going to be scored OB-19. If I do, I'm going to be scored OB-19. To me, that's not the consideration. The consideration by defendants are, am I going to get caught with this or not? Am I going to get in trouble with this or not? Or potentially, can I get this back into the jail or not? And certainly making those sort of decisions, I'm not sure if something that we should encourage. And I do feel that if the case law comes out and the precedent comes out the way that it's being asked, that any defendant that brings drugs into the jail, as long as they don't get them past booking, OV-19 will not be scored. To me, that has the opposite effect of encouraging individuals to try to divest themselves of controlled substance in an inappropriate manner.
Counselor, you mentioned People versus Ward, and in that concurrence, Justice Young really emphasized that the person knowingly carried these narcotics into the jail. And brother counselor has talked about the sort of how Mr. Morris ended up in the facility. So that sort of question about his conduct in getting there. So I'd like you to address that.
Yes, so People v. Ward, the way that I understand the facts was the defendant went to the Michigan State Police Post, I believe, to meet and have some sort of an interview. That was kind of a ruse because they were going to arrest him on open warrants. They arrested him. He didn't disclose that he had any other controlled substances on him, so they took him to the jail, at which point they then found the controlled substances. So within that confines, certainly it was a voluntary behavior of him to go to the police station with the drugs on him. Certainly in this case is a little bit factually different. And it's factually different in the sense that the defendant was going about his business when he was arrested on a parole hold. At which point there was some resisting and obstructing, so there was that charge, and then obviously the conduct later. So certainly when he woke up that morning, did he go, I'm going to go to jail today? He didn't. But he still had the voluntary thought to have at that point in time Suboxone, as this court already discussed, was disclosed, and then methamphetamine as well, which was found falling from his belongings. So I do think that there was still more purposeful conduct from him to have that controlled substance on him. And to me, it would still be appropriately within the confines of OV-19.
Does he have to purposely intend to have the substance on him at the facility? Or
I don't-
in a way that threatens? So if we look at the language of the provision, right? Conduct
So-
that threatens.
Yeah, so again, going to the test that was enunciated in Dixon. So does he have to intend to threaten the security of the jail? My position on that would be no, because the OV is written as his conduct threatened the security of the jail. You can engage in conduct unintentionally that still creates that threat. And again, when we're looking at the offense variables, we're looking at creating a proportional sentence. There is an avenue here to alleviate some of these concerns that if you have a defendant that's engaging in behavior that threatens the security of the jail, results in 25 points, but it's more minimal. The court understands why there's that behavior. The court understands why they did that. The court can deviate from the guidelines and not have any issue with that. The court can minimize the effects of that within the sentencing guideline. So when we're looking at...
You said in your opening, and I think it's probably correct, that the purpose of OVs, right, is to eliminate a disparity. And we're looking at what the legislature's intent was in assessing 25 points. And what do we make of the fact that the legislature put, you know, a arrestee having meth fall out of his pocket in the booking area on par with a scoring of 25 points for supporting terrorism under OV-20, leaving a victim with life-threatening or permanently incapacitating injury under OV-3, and on the other side, even using force or a threat of force to interfere with the administration of justice is only 15 points. So how do we, recognizing that it's to try and eliminate disparity and we're supposed to be viewing what the legislature intended for that, why shouldn't we look at where this sort of falls in relation to those comparable conduct that counts 25 points and conduct that counts for less?
Yeah, and I can certainly appreciate the obvious differences in those behaviors. So obviously terrorism is something that would be much more significant than introducing controlled substances within a jail facility or a prison facility. You know, unfortunately, I'm not really in a position to tell you why the legislature phrased those in that way, shape, or form. You know, what I can say is when we're looking at the offense variables in total and we're looking at the points assigned, and I've never been a judge. I'm not sure 100% what the thought process is of a judge when they're sentencing, but certainly if somebody is misbehaving within a prison context or a jail context or the booking context or in the court context, that would be something that would show that they have the inability to follow direction and inability to follow the law. So certainly I could see assigning a higher point value to that. Whether or not that should be the same as terrorism, I can certainly appreciate that. The differences between the two, I don't really have a good answer for you on that.
Counsel, what do we do about the sort of, based on your argument, that you have this difference between someone who's during arrest, the drug, you know, there's a frisk and they find the drugs, arrest the person, bring him to the jail, no OV-19 problem, versus didn't find it in the jail, part of the booking process, find the drugs. Why is there a difference?
Yeah, so the difference is there's behavior that occurs during that frisk on the roadside that certainly could prevent the finding of controlled substances. And again, I'm speaking generally here because we do not have those facts in this case in front of the court. But we've had defendants in the past in my career who have moved drugs from one pocket to another while they're being frisked, that have had internal and external pockets so they can move them from the internal to the external, or they have them concealed somewhere else upon their body that they're not going to be able to find. We have videos of inmates being booked into the Branch County Jail that are removing substances from crevices of their person and different things. We've also had scenarios, if we're speaking about whether or not the booking area is part of the jail. Recently, we had a case where an inmate threw methamphetamine on the floor, and the trustees who cleaned the booking area found the methamphetamine on the floor. So certainly, because the police officers did not find the controlled substance, to me, that's not the end-all be-all of OV-19. Police officers, when they're on the road, are tasked with the very difficult task of not only arresting somebody, securing them, getting them from the scene. There's many things that could occur on the road that might result in a more shorter frisk on the scene. If it's the weather, if it's somebody around there that's creating a disturbance, if it's a need to get somebody back, if the defendant's unruly. So when I read in People v. Hines that we talk about that it might encourage police officers to not search a defendant thoroughly on the road in hopes of getting additional charges into the jail, I pose two things to that. One, in my experience with law enforcement officers, that's never the case. Law enforcement officers are not worried about OV-19. They're not worried about finding more charges. They're not worried about trapping defendants. They're worried about getting somebody in custody and getting them to the spot that they need to be. The second thing on that would be, is it creates this idea that somehow possessing contraband in a jail, which is a 5-year felony, is more significant than possessing methamphetamine on the road, which is a 10-year felony. So if a police officer found methamphetamine on a subject on the road, it's the same penalty as if you actually found it within the jail. So when I read Hines, I was a little taken aback by the idea that we would have this thought process that law enforcement would create this scenario. I think that would be very untenable, and I think it would be a very uncommon situation.
So is there any significance, so my understanding from the witness interview is that as Mr. Morris is folding up his pants, something fell out of the pocket, right?
Yep.
Or these drugs fell out of the pocket. I'm wondering if the pants were never going into the jail, correct? Like if the drugs had stayed in his pocket, he is literally disgorging them because the pants are not going with him. So I wonder, is that relevant at all to this idea of whether or not it actually threatens the safety of the penal institution? If he had just taken them all out as they're asking and put it all out on the mat, but he's literally, if it's in his pants and he's turning over his pants, not putting them back on to go back into the jail. So why is that not?
Yeah, so I think in our case, the facts as indicated in the police report and the PSI were, as the defendant was folding up his pants, a substance fell from his pants area. Again, we've had scenarios where individuals have thrown it as they're doing that because they're able finally to get it out of the view of the corrections officer. Certainly if the controlled substances stayed within the pant area, one, they would search those pants again when they go to put them in lockup, so they would probably still find it. And at that point in time, it's not going onto the ground. I think we're assuming for a moment, factually, that the substance did just by happenstance come out of the pocket. The trial court judge in this case did hear that statement of the defendant going, well, I'm not saying it fell out of my pocket, but I'm saying I pointed it out.
If it had stayed in his pocket, could he be scored? And like you said, later they'll search his pants and they find it, would he be scored that?
If it stays in his pants, I would say at that point in time, most likely not, unless if he's engaging in other mischievous behavior to try to conceal that and hide that. And again, we've had scenarios with that in the past where we've not scored OV-19 similar to that.
So is that sort of just a discretionary decision?
I wouldn't say it's discretionary. I think it's looking at the facts surrounding the circumstances of the case and whether or not his conduct did or did not threaten the security of the jail. Yeah, the context matters. Correct, and that's where I go back to the example that I used earlier about an individual that comes in and they go, yes, I have meth in my pocket. Certainly they're within the confines of the jail. Certainly that's still a dangerous substance within the confines of the jail. But their behavior at that point in time is not creating a threat. It's minimizing the threat by saying, I have this on my person. You need to take this away from me. That minimizes, and actually OV-19 directly talks about a defendant that does not engage in conduct that threatens the security of the penal institution. You get 0 points. So I would argue in that scenario they're not threatening him.
Thank you very much.
You're welcome.
The case will be submitted.
Thank you, Your Honors.